Hey guys, I'm back with the series on IPR and Cyber Law Paper Solution 2016. Last lecture, we already finished our discussion till digital copyright issue, that is question 2, sub-question C. In this lecture, we are going to continue the same discussion with question 2, sub-question D. And in this question, they are asking to write a note on WIPO Treaty. WIPO stands for World Intellectual Property Organization. So whenever we think about international level patent rights, international level copyrights, international level trademark rights, so how Apple or any international company can secure their rights in other countries. So how they secure? With the help of international level agreement which are signed under this particular organization. Remember WIPO, World Intellectual Property Organization, and under this particular organization we and many other countries signed different international level agreements with respect to intellectual property. So this particular organization is fully responsible to protect one country's intellectual property in some other country. So for example, if I want to register my idea, if I want to get patent over my idea at international level, then I have to file an application with respect to PCT, that is Patent Cooperation Treaty. That is an international agreement which is signed under an organization which is called as WIPO. After filing that application, it goes in a long process. So we are not going to discuss the whole process right now, but I hope it is very clear now. So the same way on international level, if I want to secure my intellectual property, right, some movie or some international, if I publish one book, and if that book is if that publisher is going to circulate the same book in different countries, so how one should make sure that other people or other country, they do not create duplicate copy of the same reference book or that same book, and how we can claim if someone do the same. So how we can claim, or where do we file a complaint? Under dispute settlement mechanism which is provided under WIPO. So let's just discuss two treaties which is signed under this particular part. Now one is WCT, that is World Intellectual Property Organization Copyright Treaty. Second is WPPT, that is World Intellectual Property Organization Performance and Phonograms Treaty. In this particular treaty, we are going to discuss about the rights of performer, actor, singer, and also rights of phonograms, that is rights over those particular material with respect to director's right and other things. And in copyright treaty, we are going to discuss copyright rules at international level. Let's start the discussion. Here I have just provided 4 lines on what is WCT, what is WPPT, and as you can see, most of these agreements are signed in Paris or Switzerland somewhere. So you can just write it down these points. So let's start discussion with WPPT, that is World Intellectual Property Organization Performances and Phonograms Treaty. So first, it is basically divided in 2 parts, as you can see. In first part, we are going to purely discuss rights granted or rights of actor, singer and musician who worked in that movie or in that particular stage show. So what are the rights? Economic rights we are talking about. Means a person who can actually earn money out of this. So first is economic right with respect to actor, singer and musician. So they have right to reproduction, they have right to distribute, they have right to rental, and they can also make the copy available. Right of reproduction means if we have one song which belong to some old movie, so if another singer wants to remake the same song, then this right basically allows them. Right of distribution, whether I can sell the same property to some channels, like we have Setmax and Z Cinema and many other movie channels who basically broadcast different movies. So how can they broadcast and how can they take the rights of those movies? broadcasting rights with the help of this. So whether one can distribute that intellectual property and to whom they can distribute, that this particular right defines. Then right of rental. So if I distribute, so how we are going to distribute? We are going to distribute that property on a rental basis. For example, if we talk about Setmax, you often find one movie broadcasting on Setmax, that is Suryavansham, right? So that particular movie is basically on a rental basis. So for 1 year or for 2 years, Setmax purchase the rights of that particular movie. So now they can play it for n number of times. So whenever they don't find any other better movie, they basically play one movie only. Then the right of making it available. So whether we can make it available to public sphere or at the public at large, that is also defined under this. Now, as you can see, this 4 rights, the same 4 rights provided to producer as well. So you just need to remember this 4 rights, concept is same now, but here this 4 rights we are going to discuss in terms of producer. I hope it is very much clear with you now. Now, the second treaty we are going to discuss. Second treaty is WCT, that is World Intellectual Property Organization Copyright Treaty. Here basically we are going to talk rights, that is copyrights with respect to computer programs and other such things. So operating system, some games or some website or material which we provide on those website, or a code or algorithm which I have used to create that particular website. So rights granted to author. Author means the developer or main person who owns that particular software. So right of distribution. Distribution means whether others can use my particular software or not, on which condition, that is defined under this particular right. Then next is right of rental. For example, I am using one software to create videos, tutorials for you guys, okay, on a YouTube. So I have purchased one software on a rental basis. So the same way we can rent computer programs, movies, and work embodied on phonograms. So I have already given you example about Setmax and Suryavansham. The same you can relate here as well. And the last and final right is a broader right of communication to a public. So whether we can circulate the same thing in public sphere or not, those rights are also granted to author or the owner of that particular movie only. And at the same time, second part where we are discussing about the compilation of data or other material, that is databases in any form, which by reason of selection or arrangement of their content constitute intellectual creation. So but a person who owns that particular website, he is obviously going to purchase or he is obviously going to store some information from their customers or from their account holders. So those details we are going to store in a database. So obviously we should handle those database with a care, and what rights we have on those database, and whether we can use it for which type of purposes, whether we can forward the same data to third party or not. All these points are described here. I hope it is clear now. Now, in this particular part, we are going to start the discussion about question number 3, sub-question, where we are going to start this particular topic, like explain the types of assignments. Now, assignment means assigning rights of your intellectual property to some other person. I have just listed out definition. What is assignment? Assignment is a term used with similar meaning in a law of contract and in a law of real estate. In both instances, it encompasses the transfer of rights. Remember what we are doing? We are assigning some rights. For example, in file, we can say I can assign you right over file to read, write, or execute. So these are rights which I can assign you if I am a owner of that particular file. The same way, if I am a owner of any intellectual property, then on that particular intellectual property also I can assign some rights to you. So how we are going to assign that right? With the help of official document, that is an assignment. Here I have also provided example that third party is involved. For example, a borrower borrows the money from a local bank. The local bank receives a mortgage. Yes, against a loan, we basically provide some mortgage, and then only they can provide you some loan. So this is one example. You can just read this example. Assignment of copyright. So basically, for allotment of copyright, we don't basically provide, we don't create assignment at that point of time. We create agreement. We'll discuss in future lecture about agreements and licenses as well. So remember, often students make mistakes between assignments, licenses, and agreement. So assignments, there are three types of assignments: legal, equitable, mortgage. There are different types of licenses, that is sole, exclusive, non-exclusive, and there are different types of agreement that we'll discuss in a future lecture. For example, technology, franchisee, joint venture, and copyright. These are the types of agreement we'll discuss in future lecture. But just remember, don't get confused and don't make mistake while describing your answer in exam. So there are three types of assignments: legal, equitable, and mortgage. Legal, here we are going to assign some rights. As you can see, patent, existing patent through an agreement. So I can assign rights over my idea, that is patented idea. My patent I can assign to some second person. A legal assignee means to whom we are going to assign rights over that particular patent. A legal assignee has the right to have his name entered in the register, patent minting. So who's going to assign me a patent or a certification over my idea? The controller office. So when we basically sign an assignment with some second party, so his name is also going to be registered at controller office. That my name, if that intellectual property or that patent belongs to me, and a person whom I'm going to assign my patent. Then equitable. In equitable, we don't assign. In equitable, we don't need to register the name of person to whom I'm going to assign my patent. So controller office does not mention the name of person to whom I have assigned my patent. That's it. So equitable, any document such as letter not being an agreement which is duly registered controller, in which patentee agrees to give another person certain defined rights. So some rights I'm going to assign to some other person, but the difference is that controller office not going to mention. In controller office, we don't need to mention the name of a person to whom I'm going to assign my patent rights. And the last one, that is mortgage. We already know about mortgage. So if I assign my patent to some other person, rights over my patent to some other person, in return as a security, that particular person needs to deposit some money. So that is a mortgage. A mortgage is also a form of assignment. Mortgage is a document transferring the patent rights either wholly or partly. Remember, I can either transfer the whole idea, I can assign the whole patented idea to a person, or only half or part of that particular. For example, I can give you read, write, and execute permission over a file, or I can give you partly rights, that is only read permission, that is a PDF document. So you don't have full right or whole right over that particular document. You can just read that particular document. So that is partly. The same way in patent also, I can just assign some rights over my patent, not full rights. So patentee means to whom we are going to assign our patent, is entitled to have a patent retransferred to him on refund of the money. So we have kept some amount as a deposit, that is a mortgage, while assigning patent rights to some second person. And whenever he gives me those rights, then in return will release that particular deposit or a mortgage. I hope it is clear. So in next lecture, we'll start discussing about question 3, sub question B. Thank you.